Today on The Download, we're navigating usage rights with Director of Legal Risk Mitigation, Heather Cameron, Rights and Clearance Manager, Patty Locke. Plus, we'll answer your questions in our live Q&A. Now, here's your host, Jennifer Kelly.
Hi, yes, it's me, Jennifer Kelly, Senior Customer Success Manager here at Getty, welcoming you to the download presented by Getty Images. Some quick housekeeping before we jump into today's program. As always, I want to give a big shout out to all of our current Getty Images customers joining us today, and thank you for your business. We truly appreciate it. Some portions of today's program have been pre-recorded, but don't forget to drop your questions in the Q&A below, and we'll answer them live later in the show. And finally, we'll email a link to a recording of today's session later this week. So watch your inbox and be sure to share with your colleagues. All right, the house is kept. Let's get to it. Earlier this year, the ladies of the fine print helped us kick off our series on navigating intellectual property and usage rights with a focus on copyright. Joining me now for part 2 of that discussion are the often imitated, but the never duplicated, Heather Cameron and her partner in crime, Patty Locke. Welcome back to the show, ladies.
Thanks, Jen.
Hi, Jennifer.
Hi, ladies. As a reminder to our audience, Heather and Patty are not lawyers. And unlike Kim Kardashian, they don't play one on TV. So they can't provide legal advice. Everything you're about to hear is for informational purposes only. What do we need to know about people and their rights of privacy and publicity?
Okay, Jennifer, are you ready? This is going to be a little bit boring, but then really informative. Okay, so in the United States, rights of privacy and publicity, often referred to as ROP. They can vary state to state, and it can either be a common law right or specifically noted in a state statute as to what the rules are for that particular location. But the right of privacy specifically is an individual's right to be left alone. It includes protection against intrusion into one's private affairs and use of one's name or likeness for commercial use. Now, the right of publicity is the right to control and profit from the use of one's name, likeness, voice, biographical information, and imagery for commercial purposes such as advertising. Now, outside the United States, there can be similar legal concepts, but they aren't necessarily known as ROP. Many countries reference other intellectual property laws like the concept of passing off, endorsing a product or service without consent, excuse me, as well as personal and business torts.
Tort. Okay, Heather, as a foodie, I do love a good tort with an E, and that is a delicious baked dessert, as you all know. But I think you meant the legal kind of tort. So tell us, what is that?
A tort is an act or omission that gives rise to injury or harm to another. So we always advocate for avoiding harm to others. Knowing more about these concepts can definitely help you make better choices and, most importantly, avoid claims and litigation. It's expensive. Don't do it. Okay, so I gave some basic definitions about what ROP is, and it may interest you to know that some states here in the US, that right of publicity can extend after death. So depending on where a person was legally domiciled, you have to think about those rules in that context. For example, our friend Elvis, he can never ever leave the building because the state of Tennessee has a perpetual post-mortem right of publicity. The Elvis estate can always enforce his ROP. In California, it's 70 years after death. And just in the last few years, New York State has enacted a statute that provides for postmortem ROP, which lasts for 40 years. So this state-by-state approach and this global patchwork of rights, it can feel daunting at times, but here's how we think about it in relation to our content buckets. Our creative pre-shot library, our creative royalty-free content, often depicts fully released people. This means that the models that are depicted have signed model releases.
So for those of us who may not be familiar, what exactly is a model release?
We love them. Let's take a look at one. So this is the Getty Images and iStock model release that we offer to our contributors and they often use in their photo shoots. It's a legal contract between a content creator and the people depicted in a photo or video where those people specifically agree to a very broad grant of rights, including advertising uses. So we're seeing the English language release here displayed while I'm chatting about this, but we have our model releases translated into 30 languages and counting to help our content creators better communicate with models all over the globe. Now, in most countries, the model release that we provide to our contributors, it's perpetual and it's binding on the model's heirs, which means in the event of a model's death, the model release endures and can't be canceled. We love model releases for the grant of rights that they provide so that our customers can do what they need to do for all kinds of uses, but also because of how much great metadata is on them. These releases tell us specifically where a photo shoot took place, the age of the models at the time of that shoot, and any other kind of voluntary information a model wishes to provide, like how the model identifies, their ethnicity, or their gender. Excuse me. Some industries have legal or industry trade association rules about the age of models at the time content was created to make sure those models are old enough to be legally or subject to rules used within advertising. Industries like alcohol, tobacco, and certain pharmaceutical products might really care about that. So if you ever need to know the age of a model at the time of a shoot, you should just ask your rep.
So, Heather, one thing to note is that not all model releases are created equal. So, while
True.
the Getty Images release has a very broad grant of rights, creative content outside the Getty galaxy could have a time limit or maybe use restrictions. Now, I don't know why you would, but if you do source content elsewhere, you can always you can always check the fine print to make sure the model release works for your specific project.
True.
And something that comes up quite often and can be subjective, question for you ladies. If a use of our content feels like it might be sensitive or could be seen as defamatory, can customers still use that image?
Well, it's that eternal answer that people don't love, but the answer is it really depends. So we can't give you legal advice. I'm sorry. We should keep like a bingo card or like a scratch card how many times we say it. Every time we say we can't give you legal advice, like, everybody takes a drink of their coffee or whatever you're drinking when you're watching this. Okay, we can't give you legal advice, but we do recommend that you have a look at your premium access agreement for guidance. So, in the model release that we showed you, it says that it allows for any purpose except pornographic or defamatory uses. And in our license agreement that we're showing you in section 3A, that same language is echoed. And we also give instruction about what to do in section 3D, such as adding a disclaimer.
So, adding a disclaimer that states the person depicted in an image is a model may work for some of our customers' intended uses, but I know there are times when adding a disclaimer may not fit their creative vision. So, for those customers, you might want to consider getting additional permission from a model above and beyond the Getty Images release. If you want to advertise, say, that a model has a specific medical condition, or maybe you want to alter the content in a way that visualizes a certain condition. If this ever comes up for you, just let your rep know so that you can get referred to my team in rights and clearance. So for a fee, we can clear your bespoke use with the model if you don't want to include that disclaimer.
From a claims perspective, I can remind you that if you want to advertise that a model is a criminal or maybe an addict, please be sure to make time to check in with your own legal or business affairs team and check our license agreement, specifically your premium access agreement. If you want to learn more about some of our experiences with model claims, feel free to check out a special edition of the fine print from last year, Tales from the Legal Claims Script, Halloween costumes included.
Then, Patty, how do our customers know if an asset is model released? I know that some premium access customers download from a thumbnail on the search results page, and they might not see that information as to the release status.
That's a really good point, Jennifer. So, some premium access customers might be tempted to download content from a thumbnail without actually opening up the asset detail page. Depending on your use, it could be very important to confirm if the model, if the asset has model releases attached. So, we do recommend you check the release status. Let's take a look at our website and show everyone what the asset detail page actually looks like. If you notice in that red box, this image is marked as model and property released. An image like this one lives in our creative pre-shot collection. This type of imagery is specifically shot for commercial uses. So once licensed, you would be indemnified under our license agreement for the copyright to the image and what is featured. Now, let's move on to editorial imagery and back to that cute little red box. All of our news, sports, entertainment, most of our archival content, and our editorial RF offering will be marked not released. This kind of content is fundamentally different from our creative pre-shot library, where so much of the content is released or marked no release required.
So this comes up a lot and can cause a lot of confusion with clients. Can you speak to why editorial content isn't released?
Yes, our news, sport, entertainment, and archive collections are chock full of unreleased people, places, and things. And because that content was created to capture and document a newsworthy moment in time, it's not released. Our photographers covering a conflict zone at the biggest events in sports in the world, at a movie premiere, on a global concert tour with an epically famous person, or at a political rally, for example, they are not stopping to ask folks for a model release because none is actually required for editorial use, such as a newspaper article or a documentary. Now, a commercial use, by way of contrast, a non editorial use, that can be intended to sell a product, raise some money, promote a company's goods or services, and it can be things like advertising, product packaging, or merchandise. If a customer wants to license one of these images that we're showing you here for use in an ad, we would actually recommend seeking permission, as these people have valid rights of publicity and they have the right to control the use of their likeness for commercial uses.
So, with a few exceptions, if you were to license an image or video which is intended for editorial use, you would be 100% indemnified for the copyright of the asset, even if licensed for a commercial use, but you wouldn't be indemnified for the people, places, and things that are featured within that piece of content. So, for those who are unsure what indemnified means, think of it as who will stand in your shoes if something comes up and a claim is made. An indemnity means that the party offering the indemnity assumes a responsibility, so you don't have liability. Getty Images indemnifies our customers for the copyright only on our editorial content. So, let's say a photographer or a videographer comes forward and claims that we did not have the right to license the copyright to our customers. Getty Images, not our customers, handles that claim. Now, for released creative content, we indemnified for both the copyright and the released elements, such as any models within that content. So, if you want to use editorial content in one of your projects, there are questions you should ask yourself, such as: is your use editorial or is it commercial? How are you using the content? And are there any potential rights holders featured within that content? I know all of this can be a lot to take in, and I know it's a lot. So, to help our customers, we created a bite sized webinar and a decision tree, both that can be accessed on our website to help you think through using unreleased content.
Okay, so Patty, now this image, I mean, icon status, so great in our archival collection, definitely intended for editorial uses. It is not released by the Kings. Does this mean it can never be used for commercial use, like a TV commercial or maybe a social media sponsored post?
Heather, I never say never. We just have to think through a few things. Both the Getty Images rights and clearance team and the research team can help. So, first, our research team will check to see if our content partners are okay with the commercial use. We call this a collection approval. And then from there, our rights and clearance team can help review what's depicted and assess what additional rights and permissions may be needed to use content in a commercial way.
Okay, so Patty, in some instances where clearances aren't really possible, does that mean that all is lost and a commercial use of unreleased content is out of the question?
No, we're all about finding solutions. If a
I love that
customer,
about us.
yes, I do too. If a customer has concerns about using unreleased third party elements within our content, such as the unknown people seen in these images, our image guarantee offering may be the perfect solution for your project as it can expand your creative options by allowing you to safely use content that's not released. So, the image guarantee is a fee based indemnification. I think that might have been like the 30th time I said the word indemnification already. But
Everybody take a sip of your drink.
exactly. So it is what it is. It's a legal addendum to our content license, and it means that Getty Images takes on the risk of your use of the unreleased materials. If you were to receive a claim, Getty Images would handle that claim on your behalf. Now, I do want to point out that while the RNC team can clear properties outside the Getty Galaxy on behalf of our customers, as such, a film clip or an iconic piece of music, the image guarantee service is only available for content that Getty owns or represents because it ties back to our license agreement. Now, Heather, earlier you mentioned needing releases for recognizable people for commercial uses. I want to remind folks that while it may be tempting to use content of people whose faces are completely obscured, like a NASA astronaut in a spacesuit, that might not be the greatest idea.
Think
So,
it through, people.
exactly. So an astronaut may still have publicity rights that should be cleared for a commercial use, and they or their estates can recognize themselves in imagery. So, a little background for you. When Neil Armstrong and Buzz Aldrin were on the moon, NASA could not visually tell who was where at any given moment as they were moving around, as they wore identical suits. So on the next mission and every mission after, NASA started making their suits differently so they could see where each astronaut was at any given moment. So this image features Alan Shepard. I know this because his suit was marked with red stripes, and this is one of his most iconic photos. Alan still has valid publicity rights as he was domiciled in the state of California at the time of his death. And we would recommend clearing him with his estate for any commercial uses. And just an FYI, if you ever need help clearing astronauts, give us a call. We have cleared many astronauts and NASA employees over the years, so we may already have relationships in place that we can leverage on your behalf.
So, ladies, what are your top 3 takeaways for people?
Well, I'll kick us off. I just want to remind everybody, just like a copyright owner, people get to be pretty bossy about who does what with their likeness for non-editorial uses. So be thoughtful.
If the content isn't released and you want to use it for a commercial project, make sure to speak to your legal and business affairs team. And you can always contact us to see what solutions we may be able to offer you, such as a clearance or an image guarantee that would secure the unreleased elements for your non editorial projects.
And then lastly, read the fine print in your license agreement and follow the rules about disclaimers. Okay, let's move on into chatting about things. What intellectual property rights relate to things?
Great question. It could be a few things that relate to things. So it could be copyright, like we talked about in our last download session earlier this year, but also it could be things like trademarks, design marks, logos. A trademark can be a word, a symbol, a color, a phrase, a shape, even a smell. Who knew? That is used as a product or service brand to distinguish one's goods and services from the goods and services of others. So you can just go open your refrigerator right now. I mean, maybe not right now because I'm talking, but like after this, and just take a look at all the condiments you have going on there. Not just the name brands that are registered, but also the shapes of the bottles for those condiments. A trademark is an exclusive right that belongs to the trademark owner, meaning trademark owner gets to be pretty bossy and forbid others from using their trademark or a confusingly similar sign for an identical or confusingly similar product or service. Companies which go through the time and expense to secure trademark registrations, you really have to use them or lose them, meaning those registrations have a shelf life and must be used to be extended.
So then, ladies of the fine print, when our clients are looking at content on our site, is there a difference in our creative pre-shot library versus our news, sport, entertainment, and archival content?
I'm so glad you asked because yes, and that's completely by design. Our creative pre-shot library, we want it to be extra squeaky clean and hygienic for you. We want it to be used for all kinds of things, even editorial uses like writing a news article or something a lot more commercial like making product packaging or advertising. So, on purpose, our inspection team completely vets our creative content to make sure that there are no trademark protected objects or logos that are sneaking in there. So, the image that we see on the screen here, it's one of those typically squeaky clean ones with no branding by design. But as many of you may have noticed, our editorial content is chock full of them, whether it's our red carpet coverage on a step and repeat or maybe at a sports stadium with all the event sponsor logos. But Patty, how did trademarks come up in your world? And what do you want our customers to know about them?
In the category of things, trademarks are, of course, visible in product shots. And like Heather said, they are seen on sponsor signage, in the background at sporting events, the step and repeat at entertainment events, and in archival imagery. I'm sure all of you watching us now are very aware of how protected brands are and their logos and trademarks. Something I've seen many times is that a customer may want to use editorial imagery for commercial use, such as the nurses in this image. And we'll say that, well, we'll just wipe the logo off the soda machine and, then they don't have to worry about trademarks. Well, that's not quite accurate because what they haven't considered is the shape of the Coca Cola bottle. It's protected. So many objects have design protections that may need to be considered for non editorial uses, such as a Coca Cola bottle and the other shapes that you see here. And then Heather mentioned earlier how colors can be trademarked. So Tiffany's Robin Egg Blue is protected, so competing jewelry brands can't use it and cause confusion in the marketplace. And then there are other protected colors, as you see again on the screen. Now, if a color is trademarked, it doesn't automatically mean that you can't use that color in your project. But if you're producing a campaign for a competing brand, you do need to think very carefully about how trademarks are going to be affected. So, did you know that the smell of Play Doh is trademarked? I didn't until recently.
Blew my mind.
I know. And you can trademark a sound. NBC has a trademark on their chimes. Other protected trademarks include Tarzan's yell, the stopwatch at the start of 60 Minutes, and the cute little Pillsbury Doughboy giggle, just to name a few. And something you may not have known is even Darth Vader's breathing is protected. The mark is defined as the sound of rhythmic, mechanical human breathing created by breathing through a scuba tank regulator. Oh, and the hum of that lightsaber he's holding, you guessed it, it's trademark too.
That's so cool. I love trademarks. Okay, so originality with branding is just as important as copyright, where you don't want anything to be substantially similar. Be original. Be an original. I love that. Remember that trademark owners are obligated to police their own marks and watch for how others might be using them or boosting off of their portfolios. If you're a creative and you're not sure if what you're doing for a brand client is too similar to someone else's trademarks or their ad campaigns, it is a great idea to pause. Loop in legal or business affairs team for help. Everybody take a sip.
So there's a theme here, Heather. Check with your resident experts. So, what if a customer wants to use our content to create their own trademark or logo? Can we license that for that kind of can we license for that kind of use?
That is a really great question. You should contact your rep and you should ask about our trademark use writer. Now, this grants customers a limited right to permit trademark use for a logo in exchange for an enhanced license fee. So, because our creative royalty free content is available for everyone to license, it's not exclusive to individual customers. We have language in our content license agreement that restricts customers from using our content in logos. You can take a look at section 3J if you're really curious. For the brand customers watching this webinar, you all know that it takes so much time, so much effort, and a lot of financial resources to develop, register, and bring a trademark to market. So you want to be sure you have all the right permissions in place. I have had a very sad experience, maybe more than one actually, where a company hired a graphic designer to create a new logo. That company then saw what they thought, not really, but what they thought was their shiny new logo showing up on our iStock website, and they immediately assumed iStock was infringing on their trademark. Turned out that designer did not secure a trademark use rider, and they used our content despite very specific restrictions. So if you want something to be truly exclusive to your company, to make it into a trademark or a logo, and you really want that one to shine, nobody else can use it, nobody else has ever used it, we can shoot it for you, or you can talk to us about a buyout where you're buying out the copyright in order to create a trademark. You just call your rep because solutions are available on demand.
All right, ladies, what are our top 3 takeaways for things?
I just want to remind everybody that trademarks are everywhere. They're everywhere. And also, we're constantly learning about new ones, new design marks and new word marks. So, resources that you may want to check out if you're curious are the US Patent and Trademark Office website and the WIPO Global Brand Database. It's really good. We'll show you some links.
Yeah. And you should consider how you want to use the content. Is your use editorial or commercial? Is the content released or unreleased? If the latter, are you concerned about the lack of releases? If you are, our rights and clearance team may be able to help.
And then, do you want to feature your company's products and services in photos and videos? Ask your rep, that's me, how our AI generator or custom content service can help boost your brand signal. Let's shift gears and move on to places. Now, Heather, I've heard you say that places don't have a right of privacy the same way that people do, but isn't there such a thing as trespassing?
That's right, Jennifer. Don't do it. When it has come up with our photojournalists, I like to remind them I have their bail money, but I don't want them to do it either. Okay, so for our creative pre-shot library, we want our contributors to secure property releases for shooting someone's home or private business. Like with our model releases, the Getty Images and iStock property release allows a very broad grant of rights, including advertising. So when shooting in someone's home, an office, a clinic, a hospital, a boutique, whatever the case may be, our contributors have to be thoughtful about the location where they're shooting and securing permission for that, but also what's on display in addition to any models that might be featured.
This is true. A photographer should look around and consider if there are any photographs or artwork on the walls that may require releases. Like, maybe my Slim Aaron pictures right there is protected by copyright, which Getty controls, so I'm good on that. Um, if they're if they're shooting in a medical setting, is there any identifiable information about a real patient or maybe a name on a, admission form?
Patty, you're reading my mind. I actually remember a time when a photographer used his own social security number on a patient form, and we had to wipe it at ingestion. That is not a good look, people. Be very thoughtful about your personally identifiable information. Public service announcement.
Oh, that's a very, very bad idea. I'm so glad we caught that. So, other things to think about, are there specific products on display, like specialty kitchen or medical equipment, or maybe a wardrobe choice with a very well known branding that may require permission from the manufacturers for a commercial use, such as a visible trademark or design mark? All things to think about when you're shooting on locations because they're covered with all kinds of things.
Location, location, location. So I know it's important in real estate because I watch Selling Sunset. Uh, but how do we think about it at Getty Images?
Well, not so much here in the United States, but elsewhere in the world. Some structures have copyright protection in the architectural design, and they may need a clearance depending on the use. Public art, even though it's out in the public and everybody can like walk right up to it, that can still have copyright protection. And some locations and related artwork, despite being so very old, they are long out of copyright. They might have some specific cultural considerations you need to consider. So, Patty, what about trademarks related to places?
That is something that may need to be considered too, depending on your final use. The shapes of structures, such as the Sydney Opera House, the Space Needle, and the New York Stock Exchange, all have design marks. Now, we have plenty of visuals in our creative, royalty free collections showing panoramic views of city skylines where you might see one of these buildings, but we intentionally avoid having them in isolation. If you ever want to feature an unreleased location, check with here we go again, check with your legal and business affairs team or contact us for an evaluation on your projects. Again, we can't give legal advice, but, we're happy to help, speak through these concepts. You can also check out our website and review the unreleased imagery page.
I love that bite-sized webinar. I think it's really helpful with that decision tree. Okay, so for our creative pre-shot library, we remind our contributors all the time, if you have to pay admission, please get permission. This applies to theme parks, museums, sporting events, concerts. Ticketed entry locations often have posted rules for photography and video, often allowing for personal use only. So you got to check the fine print. In our news, sport, and entertainment coverage of events, Getty Images often has credentialed access that allows us to be there, and that content is intended for editorial use.
Heather, can you explain what you mean by credentialed access?
Sure. For events like news, sport, and entertainment, press credentials allow media access to those events and serve as a way to control the process for individuals and larger news organizations who wish to access or move about a specific event at a specific venue. It provides the venue management and staff with information about who is authorized to be there and potentially exactly where in space and time. Some credentials can limit where a photographer can stand and shoot, like front of stage only and never backstage, or if a photographer has unlimited access out in the action as well as behind the scenes. Credentials can limit how the content may be distributed and used, such as editorial use only, and any commercial use requires additional clearance from the company producing an event, like an awards show, as well as the talent or the sport governing body or individual sport teams.
Okay, that was a lot. So, what
That was
are
a lot.
our top 3 takeaways for places? I'll start it off this time. Number 1, if you find an unreleased image or video clip of a location and you're not sure if you can use it, check out that bite-sized webinar we talked about on unreleased content on our website. And there's like you mentioned, a helpful decision tree there.
If you want to alter the content to crop in on a specific building, contact your legal and business affairs team to review. Depending on how you want to use the content and what your cropping is, you may want to consider a clearance or an image guarantee. So we're here to help you with all that.
For me, if you pay admission, get permission. That's a really easy catchphrase to remember. And I'm going to give you a bonus one. If you would like to hang out with Patty Cakes and myself and have a bespoke intellectual property with rights and clearance solutions chat that's just for your team, thinking through how you love to use our content and any questions that you might have, you just let your rep know and we can hang out.
Perfect. And as always, if you have questions, reach out to your Getty Images representative and take a sip of that coffee. All right, thanks team. Live Q&A is just moments away, but first, let me tell you about Premium Access. With a Premium Access subscription, you'll unlock a massive library of high-quality images, videos, and music. It's fully customizable, so you can adjust your plan based on downloads, number of users, usage rights, and content needs. and get all of your editorial and creative visuals in one easy-to-search place. Your premium access agreement gives you access to Getty Images collection plus 300 plus content partners and term options to fit your needs. And managing your plan is a snap with streamlined administration, invoicing, and customer service that can't be beat. Contact your Getty Images representative to learn more, or scan the QR code and complete the contact request form. All right, get your questions ready. Live Q&A starts now. Welcome back, downloaders, to today's live Q&A session. Back with me now are Heather and Patty, ready to take your questions about usage rights, people, places, and things. And as always, I can answer most, if not all, of your questions that you have about our products and services. We have about 1,300 of you joining us today. Hello. The floor is now open. So drop your
Wow.
questions in the I know, a lot, right? Drop your questions in the Q&A below and we'll get to as many as we can. So starting it off, I already see a few questions coming in. Heather, hopefully you can answer this one. It's an interesting one. If someone dies in a particular state, are their rights automatically in that state?
That is a really good question. The answer is no. It may interest you to know that if you are like on a vacation and something very sad happens, then where you're on vacation, that state does not apply. It's the state where you're legally domiciled,
Oh,
where you have
interesting.
a legal residence, where
Very
the law applies.
interesting and morbid as well. Love it. Keep them coming, people.
Agree.
Patty, I don't want to leave you out, so I'm going to
Oh,
throw
okay.
this one to you. Person says, I'm working on a project that needs some archived content. How do I find out about your indemnification on those images?
Oh, okay. Good question. So, the best way would probably be to contact your sales rep or our service team and let them know the details on your project. So, such as the asset ID numbers and the usage rights you need, and then they'll send that over to the rights and clearance team. Also, to properly assess, we will need to see a mock-up so we can understand how that content is being used so we can determine if an image guarantee would be appropriate for your project.
Yeah, this can be very daunting for people. So always just reach out to your sales rep or service
Absolutely.
team, and we can at least guide you to people who are smarter than us on those types of issues, i.e., Patty, Heather, and the gang. All right, let's see. Heather, I got one for you. You're not off the hook yet. Okay,
Okay.
what about privately owned buildings or locations? And what
Mm.
about, there's more. And what about locations and buildings owned by the government? Example, a national park.
This is a great question. We ask our contributors to do a lot of research before they make an investment and go shoot somewhere. The answer is it depends. I mean, there can be access restrictions with locations that are government buildings, for example. You probably couldn't just show up at the White House and have an expectation that you're just going to do a fully produced photo shoot with models. Probably not a good, you probably need to coordinate that particular effort with the folks that manage that particular property. So we just always advise, make sure that you take a look if there's any type of posted shoot policy. I can tell you as someone who frequents Yellowstone National Park, if you think it's a really great idea to show up and do a fully produced photo shoot with models trying to pose 5 feet away from a bison or a bear, you're going to go to jail. So don't do it. You have to follow the rules and just make sure you do some research before you invest time and expense and don't get your heart broken and don't get gored by a bison. They don't play.
A lot of
And
venues have policies online that you can look, including national parks where you
Yeah,
might think you don't need permission to shoot there,
right,
but you might. So check the websites.
right.
perfect. Thanks, ladies. And Heather, you're welcome for that bail money on the bison incident. All right, I got another one here for you, Heather. This is about model claims. You mentioned medical conditions as an example. What about use on a flyer where
Mhm.
the model is implied to be an oncology patient?
That's not a super controversial, like your average bear would probably not take issue with an oncology type of issue. Think about it more in terms of, and check in with your legal team, get some advice from your legal or business affairs team. If it's something incredibly controversial that you're trying to say about a model and you don't want to use a disclaimer, especially, definitely take some advice. And if you think you want some additional clearances for that, let us know. But it really does come down to the particular end use. But a lot of our content gets used all the time for different types of medical conditions, and our brand customers in the pharmaceutical space, especially, love our content. You're welcome. Glad we can help you with that.
Yeah, so if it's juicy, maybe check with your legal team. If it's like just a
If it's
standard
spicy,
ailment,
yeah,
yeah. If like
yeah,
incarcerated, exotic dancer, anything that subjectively could possibly be seen as controversial.
right,
Oh,
right.
Heather, this is a good one and very timely, I might add. Does the model
Okay.
release include AI use rights?
Mm. Okay, if you are referring to AI training rates, I just want to point out that our content license agreement does not allow for that anyway. So if you need those rights, you can definitely check with your rep and see what we could using AI. Then any edits using our AI tool, amazing. We've already thought that through. You could definitely do that. But if you're using other external AI tools to do that, definitely it depends on how those tools work and if those tools are training on our very precious content that you're putting into it. So definitely take a look at our content license agreement and our policy, and then check with your legal folks and make sure that those tools will work. And if you're not sure, you can contact us.
Yes.
We might have solutions for you.
Happy to help. I have Heather on speed dial, so I'll just direct them right to you. All right, Patty, I
Love
have
it.
one here for you. What types of fees are involved when clearing a model if we don't want to include a disclaimer? Oh, that's a good one.
Okay. So
Really
it's
good.
hard to quote fees without a specific project details, but in a nutshell, a model may require compensation if they agree to participate. So there would be their permission fee, which would be based on how you're using their likeness, the grant of rights you need. And then there would be our rights and clearance fees to handle the clearance, which actually includes the model's contracts, and we handle all the payments for you. So if you're ever working on a project where you feel that you might want that additional clearance for one of our creative models, just reach out to us with, again, the information I mentioned earlier, and then we can discuss what the potential fees would be and, how long it might take, et cetera.
Perfect. And want to let everyone out there, all you downloaders, know that we are aware that Heather's video is having resolution issues. We're working on it. This is a live show, everyone. Okay. And Patty, feel free, if we can't hear Heather, you and I can kind of
Absolutely.
jump in and impersonate her, I
I
guess.
blame her cat. I'm just saying that. I blame the
The
cat.
cat is walking across the keyboard. That's our
Exactly.
official statement. That being said, I have a question for Heather, so hopefully she'll be able to answer it without issue. Heather, how do you define a news article or documentary?
Oh,
A
you
lot
know
of
what?
gray area.
I
Uh,
can take that one.
Okay, sure.
So just to give her a chance to get back into the groove there. So, a news article or documentary, that would be defined as reporting news, discussing historical or current events, other public interest topics. That would be, separate than like a commercial use, which is always seen as like selling a product, raising money, or promoting, a company or their products and trying to sell them. So that would kind of be the basic difference between the two.
Yeah, and there is some gray area. So if you have a use
Definitely.
that might be advertorial, you're trying to pass off as informational, check with your legal team, see what they're comfortable with.
Oh,
Perfect. Okay, let's see. Have a question that just came in. uh, Whoever wants to answer this, just jump in. If a journalist posts on Substack for editorial purposes and also accepts payments, is that considered using a likeness or editorial use? or is it considered being used for commercial purposes? So this is Substack. It's a little bit of a specialized use, like content creators can get paid for subscribers to subscribe to their content. Would that be considered editorial or commercial, ladies?
I don't know if you can see me or
We
if
can
you
hear
can
you.
hear me. Feel free to interrupt. Feel free to interrupt me if it's not working out. It's the same. Like a lot of people pay to subscribe to different news media
Mhm.
outlets, and it's the same. It's editorial use.
Perfect. And then next question is, has everything labeled model released been independently verified by Getty, or are there images from acquired collections for which Getty relied on the original company's assertions?
I can answer that question. I work on
Sure.
all of
Oh,
those
she
different
got
kinds
out.
of things.
Maybe.
Yes, all content coming into our collection. Man, okay, let me know if I'm back
I can
or
hear
if you
you
want to
now.
come back to me.
We can hear
But
you.
we okay, sorry you guys. It is the cat. I'm scared
Live.
of it.
It's
Squirrel,
live.
where are you? First it's live. We do review all of the model releases that come in with our content, and lucky for us, the vast majority of our contributors use the Getty Images model release, which we know is amazing and dreamy. But I'm here to tell you, I have seen model releases from the 1940s, the 1950s, the 1960s. They don't look the same as the contemporary Getty Images model release. They're not as vast and descriptive, but they all include the all essential information about how they allow for advertising uses, which for a lot of our customers can be the most important thing. You want to make sure that that's allowed. So we do, I spend a lot of time looking at some of those more archival model releases, and they are good to go. If we say it's good to go, we will defend it and stand behind it.
Perfect. And that's part of what you're paying for with a license is that indemnification that we provide for you.
Yeah.
Okay, next question from one of our 1,300 viewers here. Typically, how long does it take to process clearance requests on an editorial news photo for paid advertising creative use? I know how
That's
to answer this. I'm going to throw it to you, Patty.
I would say that screams a question for me. And I know you guys are probably sick of hearing it. It depends. So
Hmm.
it would depend on who we're actually trying to clear. An A-level celebrity, or just a person who's identified at a game. It would just depend on how long it would take to find those people and negotiate it. I would say a safe bet would be, maybe aim for 2 weeks. If we know who they are and we can get in touch with them and they respond, that's great. But I can say sometimes our clearances, if there's a lot of negotiations going back and forth, it can take a little longer. So,
Yeah, and like you
but
said,
come to us and we
Also,
can help guide them. So yeah.
Pat Patty's not bragging right now, but I'm gonna brag on Patty. She's cleared global iconic people in
I
20
have.
minutes.
I have.
oh,
She's
like
got
Chris
Once.
special
Martin.
Once
skills.
was 20 minutes, not all of
She's
one
she's got
time.
relationships. It's great.
I mean, and that's key. And it really does depend because you can have the right contact, but
Yeah.
it depends on their response time. And
Yeah,
some
exactly. They
people
could be on
just
Right.
are more
vacation.
responsive. Yeah. But I
You
Right.
know,
love that you can track down regular people like
we
us.
can.
Like that detective work is fascinating to me and a
We
little
can.
scary.
We
Um,
watch everybody.
okay, here's a good one. This comes up a lot because I don't think people really understand this concept, but I'll throw this to both of you. What is the basic definition of public domain?
I'm gonna give that to
Uh,
Heather.
I feel like we talked a lot maybe about that in our copyright webinar that we did back in April. So you can go back for a refresher if you want to. But basically, it means that either someone has created content, a content owner has donated it to the public, that's a possible thing, or it's so old, it's no longer subject to any rights by a rights holder. That's a easy way to think about it.
Hmm. And we do have public domain images in our library. And what you're paying for that is just the access to it instead of having to go to the museum and,
Right.
I don't know, take it down and copy it.
And some of that stuff, is so old, we have processed it to clean it up and protect it
Hmm.
and, archive it so it will be around for many, many, many years.
Right.
Perfect. Okay, this is an interesting one. Client here, downloader, hi, says, I am most interested in restrictions with buildings like very well known
Mm.
hotels. The hotel would be photographed off their property across the street, for example. So, just focusing on the one hotel, what does that look like as far as restrictions when it comes to editorial or commercial use?
I would say a really good rule of thumb is that if you have made a lot of effort to make something the sole focus of an image, even if it's shot from across the street or it's shot from public property, but you're really making something a sole focus, I would certainly think about, depending on what the end use is, getting some permission for that or having some understanding. I think it really depends on what you're trying to do. And I know that we have some clients that are, they're in the travel industry, and it's really important to them to get sort of unique perspectives on iconic locations that can include hotels and other types of destinations. And if you are interested in having us help you think about how to shoot that kind of content safely for your campaign, let us know. I mean, just call Jen.
Just call me. I'll be ringing off the hook.
Exactly.
Um,
Right.
okay. Here's next question, obviously. Would using editorial photos for research projects be considered editorial use?
I would have to say
I would
probably,
say
but
probably.
depends
Yeah.
on
Good
the
job,
project
Danny.
itself. Yeah. Yeah, I've worked with you enough. I know how you think.
Right.
Perfect. Easy
Yeah.
enough.
Sometimes folks are doing research to sell a particular product or
Mm,
service.
hmm.
So that's something maybe to think about. But if you're doing, more empirical research where you're working on a dissertation or something like that, yes, absolutely editorial.
Okay. And next question, we kind of touched on this before, but maybe you can reiterate. What about public municipal buildings like city hall, libraries, courthouse, town commons, etc.? That goes kind of back to the government
Many, in
buildings,
my
right?
experience, yeah, yeah, in my experience, many of those places, I mean, they're owned by the public. They're owned by that municipality for the benefit of the public. But they, individual rules about accessing those locations, just like walking into a courthouse and walking into a courtroom and just you start taking photos, people are going to maybe ask for your press credentials to be there, are going to ask you some questions about sort of what you're up to. So the answer is it can vary and it can depend. So
And
just
the
Also,
do a
lesson,
little
depending which
research.
country too. Different countries have different
mm,
rules.
Right.
okay, so the lesson
Yeah.
there is get a good mock up a fake press credential and carry it with you at all times.
But hey, while we're on this topic, this just made me think of something. Patty and I, this comes up for us all the time. Washington, D.C. is such a great example because so many of the buildings there, they were paid for by the taxpayers.
Mm,
There's lots of memorials that are there. And, sometimes the Park Service manages that particular location. Other times they were privately donated memorials that are there for the public to enjoy. But there can be some confusion specifically about art and those different types of locations. So just because it's in Washington, D.C., does not mean that everything is public domain. You have to really independently research which locations still have memorials and artwork there protected. A great example is the National Cathedral. The National Cathedral has a title that sounds like it's for, they would say it is for everybody, but it is a private church. It's a private property. It is not, you can't just make an assumption that anything that's depicted there, including copyright protected artwork by a very well-known sculptor, is just available for you to use the same way that the Lincoln Memorial would be.
that's a really
And
interesting point. Yeah.
yeah, even on the national parks, they do have several pieces of art that are still protected under copyright. So it's not just a
Right,
free for all just because it's on a national park.
Oh,
right.
interesting. Okay. Here's a good one. If we license an image for commercial use, I'm assuming they're talking about an editorial image, but you can clarify. Can we make changes to the image? For instance, uh, the color of a piece of clothing or animating a waterfall?
Do you want to
Maybe.
take that one, Patty?
Yeah,
You live in
sure.
this place
It
all the time.
depends. Let me guess. It
I know, it
depends.
Mhm.
depends. So if it's an editorial image, and that's what we think this question is, then our EULA would not cover that, because as we deliver the product to you, the image to you, or the footage to you, it doesn't, give you the right necessarily to alter it. So if you were wanting to alter it, then, we can look at maybe an image guarantee that would allow
Mhm.
you to do that. We also may need to get the contributor to approve that kind of stuff too. But on the creative side, if you have a fully released image that's creative, and you want to change an article of clothing, you just go right ahead and do that.
Yeah, and that's why it's key, downloaders. Always just check with us if you have
Yeah,
questions. That's why they're talking about they want to see the finished,
exactly.
mock-up. So don't do a bait
Right.
and switch. That's not good business.
Well,
Just
and the same
Um,
with like a
one
skyline
other
shot that you might find. If you go in and crop really far in, and that building may have trademarks on it, we don't cover that cropping. So things to
Perfect.
think about.
Always things to think about. Okay. Can you describe the difference between editorial and commercial use? For instance, would a textbook or encyclopedia be considered editorial, even though the publishers are commercial publications as opposed to nonprofit?
Gosh, we get this question so often, and yes, definitely editorial in nature for a textbook usage. Um, it's so interesting that just because you sell something doesn't automatically make the use of that a commercial type of
Hmm.
usage. We get some inquiries. I'm not gonna diss any particular celebrities. Patty, you know who they are. We talk about them all the time.
Maybe in
And if
another
you want to know who
episode.
they are, yeah, 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 yeah. But we have had these inquiries before where celebrities will see pictures of themselves in our editorial collections and like, well, that's me. You have to pay me to have those
Hmm.
photos. And I'm like, but it's editorial use. We're covering you at a movie premiere and you're posing for the photographer. I mean, like, this is a newsworthy moment in time. That's the whole entire and all of the intent behind the content. But you're making money on that photo. And I was like, us licensing the copyright in a photo is not the same as your right of publicity. They are two different rights. It's pretty funny how many times I have to explain that to a lawyer, and I'm not one.
Again, we can't
But
reiterate enough,
right,
people. We're not lawyers,
I know.
but
No,
we know a lot.
Mhm.
yep.
Okay. Next question. Are copyrights automatic? Like for in the example you gave of a mural, if someone's mural shows up in a commercial, sorry, but the artist didn't file for a copyright claim, can the artist of the mural go after the person who made the commercial? Same for if someone makes a logo. Do they have to file a copyright claim? Otherwise, they can't go after someone who tries to steal their design?
Ooh, there's so many different rights to talk about
There's
in
a
that.
lot of stuff here. Yeah, this is a really robust
Yep.
question.
Yeah. So if you're a mural artist, one of the things that can often come up with Getty Images specifically, this is so interesting. And if you've ever done, I'm trying to remember if we've used this example before, but we've had it come up where artists have done murals, and then they have contacted us saying, "Hey, you have a copy of my mural on your website," and we're like, yes, we do have that on our website. We photographed you making the mural and we interviewed you. Remember? Oh yeah, yeah, yeah. But then also they can make a mural and then they've used a Getty Images photo
Mm.
as the basis of their mural. So these like rights can get very meta and very layered. But the answer is when you create a work of art that if it is yours and it is not someone else's derivative work, you have those copyright rights. And it is possible that you could pursue someone for using your artwork without your consent.
Even if you didn't
On the logo
register it.
issue, yeah. On the logo issue, can you repeat that part, Jen, of that question? What
Sure.
was the
Let
logo with
me
the copyright?
scroll back up. If someone makes a logo, do they have to file a copyright
Mhm.
claim? Otherwise, they can't go after someone who tries to steal their design.
Oh, okay. So I think if you create a logo for your business, and you could apply for a trademark and get a trademark registration for the design mark of your logo. that is great if you want to be the exclusive person in the space and have all the rights to do that. It doesn't mean if you didn't do that in advance, that you couldn't call somebody up and say, hey, I think you're copying me. You still could, but having a trademark gives you a lot more flex in that space if you wanted to be proactive about policing the use of your mark.
Perfect. And y'all downloaders, I see your questions coming in. Let you know we have so many questions coming in, but we are at time.
I love it.
So that's going to be our
Oh,
show. I know. That's going to be our show for today. Thank you for submitting your questions, and answers to everything we didn't get to, which is a lot, will be followed up on later this week. Heather, Patty, thank you so much for sharing your insights and your expertise. As a reminder, you can watch part 1 of Navigating Usage Rights along with every past episode of the download anytime on demand on our dedicated show page at gettyimages.com. You'll also find additional resources and bonus content from today's episode there. We'll drop the direct link in the chat. Say that 5 times fast. And don't forget our final show of the year, Defining 2025, Editorial Year in Review, airs December 16th. Keep an eye on your inbox and LinkedIn feed for registration details. If you have questions about usage rights, premium access, or any of the products or services we talked about today, please contact your representative or email us over at thedownload@gettyimages.com. As you exit today, there will be a quick poll for some instant feedback on today's episode. Please take a moment to let us know how we can serve you better. Thank you once again for joining us today. I've been your host, Jennifer Kelly, and we'll see you next time on The Download.